going to find that there is sufficient probable cause to continue with your case. Are you here by yourself? Who's here with you? Your grandfather? Do you live with your grandfather? Come on up. And who's here? Your grandfather and who? Your sister? Do you live with your sister? You do? All right. All right. How old are you? Okay. So make sure you're an adult. Okay. You live with your brother Dante? All right. And you are a grandfather? And are you aware of what Mr. Johnson is being charged with? Did he tell you what he's being charged with? I don't know if you heard the facts surrounding why he was arrested or charged. Did you? Okay. No, do not say anything. Do not say anything, okay? Miss Anthony, let's go ahead and let's go ahead and read probable cause again so that the family can hear.
Yes, Judge. On 4/30/2025, officer was dispatched to a suspicious person with a weapon call. Caller advised that several young males were wearing COVID-style masks and gloves, and one was armed with a pistol. Officer observed the suspect matching the description. Officer observed the defendant walk behind a light pole and drop a red jacket that he was holding and keep walking. Defendant was detained. Officer recovered a fully loaded pistol. The jacket was wrapped around the pistol with no holster. Several COVID-19 masks and gloves were located, and defendant is 18 years old.
And the weapon was found on Mr. Johnson?
Yes, Judge.
Okay.
Under the jacket.
All right. So, Mr. Johnson, you're charged with the offensive possession of a handgun. You're 18 years old. You're prohibited from possessing any firearms at your age. Okay. So you were arrested and charged with this offense, and this is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. So now you're aware of what your grandson is being charged with. Okay. Now he's an adult. You're 18 years old, Mr. Johnson. So you're an adult. Okay. So I'm going to treat you as an adult. So, Mr. Johnson, the court's going to order some conditions regarding your bond. Mr. Johnson, the court is going to order that while you're on bond, you're going to be prohibited from possessing any firearms or any weapons. Do not have any firearms or any weapons whatsoever. The court is also going to order, because of your age, that you will be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. No illegal drugs and no alcohol because of your age. Do you understand? These conditions of bond, Mr. Johnson, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, you're going to need an attorney to represent you on this case. Are you in school? All right. Are you working? Your ID. And how long have you been waiting for your ID? How long? Why so long? It doesn't take 7 months to get an ID. Okay. What, do they keep it or what? They have it? Right, you can probably go get it.
I believe he may be on a juvenile probation.
Oh, really?
I reached out to them to confirm, so that.
Can you check, do you see in your system if he is? I'm not sure if that will pop up. Will that pop up?
I can't confirm it. It does say he could have been on one. I reached out to them. They just haven't responded yet.
But your system doesn't allow you to pull anything up like that?
Not for juvenile.
I know, I
It's
understand.
separate.
I know it is separate. That's why I was asking.
but it looks like there was an evading that was disposed in January. And on the TCI, it indicates there was a probation, so I'm not sure.
January of this year?
Yes, January of this year.
Okay. Let's see. Okay. All right, Ms. Johnson. Then you're going to need an attorney to represent you on this case. What are your plans now that you graduated high school? Are you going to go to work or are you going to go back to school?
Yeah, for an electrician.
And when are you going to do that?
Whenever I get my ID.
Why don't you go get it today? It's real simple. Just go to the Texas Department of Public Safety and say, hey, I need an ID. Yes, ma'am.
It's a process. We don't have anything helping him get his birth certificate so he can get out.
He doesn't have a birth certificate. Was he born here? It shouldn't be difficult to get his birth certificate. You go over to the Bureau of Biostatistics. Are you aware?
They were there yesterday. She's supposed to be there. They called yesterday and she came to get a picture from our house to show the people. They said they need like a picture of him to make sure that it's him. She came to get the picture yesterday to see the people, but I heard her on the phone with the people. They said once she sent the picture, I think she be sending the birth certificate and then I guess they go from there.
Okay. I'm not aware of that. I mean, if you were born here in Houston, were you born here in Houston? He was? Okay. Was he born in a hospital here? No? You weren't born in a hospital? Was he born in a private residence? In a private residence he was born?
Yeah, I'm ready to pick him up at the house and the process needs going on.
I see. Do you know if he was ever issued a birth certificate? You know? No, never was? I see.
My daughter, she.
Okay, I understand. Well, Mr. Johnson, you need to get your birth certificate as quickly as you can. I mean, do what you can, okay? Now, Mr. Johnson, like I said, you're going to need an attorney to represent you on this case. I'm going to give you two options. I can reschedule your case to allow you time to hire your own lawyer, or would you like the court to appoint you an attorney this morning to represent you on this case? What would you like to do? I'm sorry? You want to get your own lawyer? How are you going to pay for it if you're not working? Well, it's his case. He should pay for it. The parents shouldn't pay for it. You shouldn't pay for it, sir. It's not your case. You should let him pay for his own lawyer. Right? So, you know what? I wouldn't pay for his lawyer. So if he wants his own lawyer, tell him to go work, do something, sell whatever he's got, pay for his own lawyer. Mr. Johnson, you're 18 years old, okay? You're an adult. Why are you letting your grandfather pay for stuff that allegedly you did? It's not his fault, is it? Okay, so why are you asking him to pay for your things? Well, I am. That's fine, but I need to know, are you going to hire your own lawyer? And who's paying for it? Who's going to pay for it? Right? Who? Why? Why is she going to pay for your lawyer? It's not her case. Do you understand what I'm saying, sir? Do you agree? Okay. Do you agree? Do you think that his mother should pay for his lawyer?
That's him and her situation. I'm not going to pay.
I know. I don't blame you. Lawyers are expensive. Lawyers are very expensive. What does your mom do? Is she working?
Yeah, she got 2 jobs.
She's got 2 jobs. Why does she have 2 jobs?
Because she wants.
Because she needs 2 jobs to make ends meet, because she needs bills to pay. Yeah, no, we all have jobs, but not everybody has 2 jobs.
Yes, I do.
You have 2 jobs? You're working all the time then?
Yes, I just got that.
Wow, you must have a lot of bills to pay then if you got 2 jobs.
I got my bills, my car note.
Yeah, I know, right? I'm sure y'all's mother too, same thing, right? You know, that's a lot to put on your mother. Now all of a sudden, you're asking her to pay for a lawyer.
If you want to wait 1 second, I can call
That's a
them.
good idea. You know how much a lawyer costs?
But there's no need for contact or anything.
Okay.
Yeah, how much a lawyer costs?
Don't realize- they don't realize what-
Yeah, you didn't, right? You think it costs $100 or something? No, how about thousands of dollars? Thousands of dollars, right? Is that right, sir? Would you agree? Thousands of dollars? So,
Depending on the situation.
I know. And so you're asking your mom to pay a lawyer thousands of dollars for your case? I'll appoint you. Office. You're gonna need one. And, you know, you don't have the funds or the job to pay for it on your own. And this is something that you should do. So I'm going to appoint you a lawyer this morning. All right. There'll be an attorney that's going to speak to you this morning. All right, Mr. Johnson, do you have any questions on anything that I've mentioned to you? All right. Right behind you at the table, behind you to your right is my pretrial officer. I want you to go with her, sign those bond conditions, have a seat. I will appoint you a lawyer, okay? Thank you. Millie?
Yes, Judge.
Page 13, Dante Johnson, court appoint. Mr. Duna, good morning. How are you? Good. How are you? What's happening?
I have a question on Jesse Lopez, Your Honor.
Yes, it's Jesse Lopez. Let's see here. Oh, let me look at it real quick. Oh, yeah. Have you seen what it was?
Yes, Judge, it looked like he had a positive blow.
Mhm.
Did not
On his interlock. Let's see what he's got. Looks like he's got an interlock in his vehicle. And is he here?
He is here.
All right, let's call him up. Jesse Lopez.
I will let you know in a second.
It's a DWI second. He had a prior DWI.
And just for
Yes.
discovery wise, Your Honor, so let's say at the one video, possibly two, that was, I think it's mainly the initial officer that
Oh, okay.
makes contact with him and does the initial detention. So I believe they put in an escalation request on that one. So that's where we are discovered.
Okay. And this case is old though, you know, this is back, looks like back last year, May of last year, May 25th. It's almost a year old. It's Constable Precinct 4. Do you see this case, Miss Anthony?
Yes, Judge.
And what video are you still needing? Is it like a station
I
video?
believe it's dash and.
Dash, yeah, because I think they have dash cams in precinct 4. Is that what your system seems to indicate, Miss Anthony? Dash?
Yes, it looks like it's the initial detaining officer that we need.
Why is it taking so long? A year? I don't get it. I don't understand. Okay. You know, I'll be honest with you. And I'm not blaming you, Miss Anthony. It's not your fault. But this is what's very frustrating. This is an offense that was alleged to occur back May 25th of last year, and you still haven't gotten, the state has not received any videos of a dash cam that is necessary for Mr. Danuna to be able to look to determine what course of action needs to do. Have you tried contacting it, or is anyone from your office is going to try to contact to get these videos ASAP?
Yes, Judge. We've reached out to the video room and they've emailed them before, but I've put in a to-do to call them. It might be better. I'm not sure.
You know,
We can talk directly.
and if they're ignoring your calls, we need to do something, okay? We cannot be just resetting this case because you haven't been able to get a hold of somebody or you're waiting on videos because of whatever reason. So I see on October 29th of last year, I have a note that says that body cams were released. Were you able to get the body cams?
Yeah,
Okay.
that we reviewed everything. There was like 3 or 4 officers on scene, so we have the majority of the video, but the main one that we're missing is that initial.
Yeah, dash cam, I understand.
officer. which as you know, it's going to be.
Oh, I know. I understand.
And to be fair to the state as well, or this, at least actually, is that it was with a prior prosecutor, and I don't know if
Yeah.
she can put those notes in.
Well,
prior to
but the state's the state. That's kind of how I look at it. I mean, whoever is responsible, the whole, district attorney's office is responsible. I do see that last time that you were here, the state was going to evaluate it. I'm assuming to see whether it's still good to go. Did you see those notes, Ms. Anthony, back on April 3rd?
Yes,
Those resets of the
Judge.
dates for the state to eval?
Yes, Judge. I've taken a look at it and we're still proceeding with it. We'll just need that video also.
All right. Okay. All right. So you're Jesse Lopez? Mr. Lopez, you're here with your attorney, Mr. DeLuna. The reason that you're here today is because I received a report from pretrial services in reference to a violation of your conditions of bond, specifically your interlock. I received a report that on, let me see, give me 1 second here. Okay. On April 27th, when you blew on your machine, it recorded alcohol on your breath. April 27th was a Sunday. So Sunday afternoon at 3:25, when you blew on your machine, it detected alcohol on your breath. And the amount of alcohol that it detected was 0.03. Now, were you given instructions, Mr. Lopez, if there's ever an indication that your machine thinks that you have alcohol on your breath, were you instructed of what to do if that happens?
Not necessarily, not that I would recall.
Yeah,
The
I think
first
that's
time I
what
did have my
okay,
first
good.
EWI, I remember, they explained it to me, but whenever I went back the second time, which in this case, that's yet had the device, and I said, yes.
Or did they give you instructions of what you are to do in case you blow and it indicates positive on your machine?
Getting rid of 3 days.
No?
Okay, cool. You follow it?
Okay, it's real simple. If you're to blow on a machine and it indicates that you have alcohol in your breath, you're supposed to blow again. They didn't tell you that?
Well, I did blow again,
Uh,
blew again, and my car turned on, but I also didn't have no alcohol on.
well, it indicates alcohol.
I got there, I'm sorry to put you off, but, I got there, got cleaned up, got in the car, and I go to the cars, but I got off the vehicle, trying to turn it on, got off the vehicle, I had my dog inside the garage, I opened it, took out running, I called him, came back in, and I blew him on the machine, and it wasn't a long time frame, because whenever I got back in the car, I heard it beep, and that's when I tried to blow it again, it didn't let me blow it, and so I turned it back on, I blew on it, and then the car turned on.
Okay, well, I'm not exactly sure how that works, all that, but you see just one blow, right?
Yes, Your Honor.
Okay,
Timeframes, one.
yeah.
Is there a way we can pull up the records for that particular?
I'd have to request it. So they're not going to give it to me today. It has to be requested. But if you want me to, I'll request it.
I mean, I guess it depends on your role.
Well, I mean, I just want to make sure that you understand, Mr. Lopez, that whenever you blow a machine and if it indicates, so it beeps if they believe you have alcohol in your breath, right? It beeps.
I'm not sure, I just know it beeps.
Yeah, it beeps.
Turn it on, it beeps, it indicates I need to blow, it beeps, so I never really look at the device because I don't consume alcohol. So I don't find that stuff for me to look at. All I don't go out, I wake up at 3, normally, that day I got out of work early.
Yeah, but this is at 3:25 in the afternoon. Yeah.
Yeah, I got out early that day.
But let's do this. You don't have to say anything about what happened. You have your attorney here. He probably doesn't want you to say anything. I'm not, the machine, when you blow on it, tests your breath. Okay? And when you blow on the machine and it indicates that you have alcohol, okay, this machine cannot tell the difference between an alcohol from an alcoholic beverage or alcohol from something else. Sometimes there's things that you drink, consume, eat that causes this machine to believe you have alcohol. I'll just give you an example. If you were to take an orange, fresh orange, peel it, eat it, because it's very sour, that could cause the machine to say, hey, you have alcohol in your breath, and you don't. Okay, but that's just, it believes you have it. So the reason we ask you to blow again is to make sure that it's not what we consider a false positive test. We want to make sure that if it's alcohol, we want to make sure if it's alcohol or not. So they should have given you instructions that if you blow in the machine, and whenever you beep, you have to check to see, because it should tell you whether they think that it indicates alcohol or not. You're supposed to blow again. You wait 5 minutes and you blow again. You wait 5 more minutes, you blow again. You have to do it 3 times. That determines whether or not it's really alcohol from an alcohol beverage or maybe not. Okay. And the reason that I received the report is because the machine believes that you drank alcohol from an alcoholic beverage. Okay. Now, all I want to do this morning, Mr. Lopez, is just give you a warning. That's all. This is a warning. Okay. I don't want to see another report that indicates alcohol on the machine. And remember, if it seems to indicate when the machine beeps, you got to blow again. Okay, so that way we can determine if it is or is not. And let me see. Is he, Ms. Garcia? Is he? Does he have random UAs too?
Yes, Your Honor, he's checking.
He is okay.
Yes.
All right, so it's just a warning, okay, Mr. Lopez. Like I said, I don't want to see another report indicating that alcohol, because you are on a bond for driving while intoxicated as a second offender, and you have a previous conviction in 2021. So I take these very seriously, okay? All right, so what we're going to do is we're going to reset your case to give time, hopefully, for the district attorney's office to provide your attorney, Mr. DeLuna, with the information and videos that he needs. And hopefully you'll get that soon, Mr. DeLuna. And then from there, your attorney's going to let you know what's going to happen with your case, okay? All right, you're welcome. Any questions, sir? So just have a seat, and we're going to reset your case in a minute, okay? So just have a seat. And then just put an escalation clause, Ms. Anthony.
Yes, Judge.
Just have a seat, Ms. Lopez. Secondly, we're going to reset this case. But you have a trial case on Tuesday too, right?
Judge, I'm actually conferring with the state and the chief on this one right now.
Okay.
We may have something worked out.
Okay.
But I'm gonna come back, but we're not done with.
Okay.
That case.
You got other courts to go to, whatever?
Yes, sure.
Okay, yeah, I'll be here all morning. So just let me know today, because I do need to know, because I have another case also set for trial. So I need to know if the state's going to be ready, you're going to be ready, and that way I can determine which case we're going to pick to go to trial, okay? So just check back with us. And on Mr. Lopez, we'll reset it. You're welcome. Yes, sir. Good morning.
Judge, on
Yes.
the other trial case, briefly, we're resolving that also.
The Martinez case?
Yes.
Okay. Oh, appreciate it. Thank you. I'm assuming Mr. Rios is going to come by, so.
Yes,
Okay. Thank you. Yes, sir. Good morning.
Morning, Your Honor. First, got a walkthrough. I can give you a close when you're ready.
Oh, hang on now. I don't normally do walkthroughs. I think I mentioned this to you last time. I normally don't do walkthroughs until about 11 because I got to clear my docket first. So what kind of case is it?
It's harassment. There's no objection on condition.
I know, but I'm not going to do a walkthrough. So come back at 11. I'll do it at 11. I need to clear my docket first. Okay, let me see. I have some other cases.
Judge, I have a check-in.
Oh, yes, ma'am. Oh, more. Thank you. And Millie, did I tell you I need an interpreter?
Okay, no, I couldn't.
Oh, I need an interpreter. Sorry.
Place it out.
It is on. Give me a second. I'll tell you who it is. On page 26, Torres Zuniga.
Oh, yes, Judge. He has another case with Edward Casanova.
Yes.
You still need the interpreter?
Well, but he's not on this case, so Mr. Counsel, so yes, I do, because I need to make sure. And then Stephanie,
Judge, he's an
it's an MRP.
And so we was going to do some.
Oh, okay.
But he picked up the river I said again.
Okay. Thanks. Okay, let's see. Jackson Bennett, coming up, sir. Good morning, sir. You are Jackson Bennett?
Yes, sir.
Mr. Bennett, you don't have a lawyer today, right?
Yes, sir.
All right, Mr. Bennett, I just wanted to inform you, sir, of what you are being charged with. You're being charged with the offense of harassment. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. I noticed that this was an offense that was alleged to have occurred back on November 16th of last year. It looks like that there was a investigation that was being done by the Harris County Precinct 4 Constable's Office. What I see is that they received a call, let's see, and they were dispatched to a criminal mischief to Applewhite Drive in Katy, which is a residence of Miss Andrea Castillo. She told the officers that, let's see, what's that? That you and her had a dating relationship for about a year. She told the officers that on that date, approximately 10 days ago, y'all recently broke up, and that she blocked you on all communications. And then she told the officers that early that morning, between 2 and 3 a.m., she was at a friend's house and was not at home when you came to her residence and was knocking on the front window of the residence. Then she told the officers you went to your vehicle, returned, let's see, went to the passenger side and slashed the passenger side front and rear tires. Okay, as well as scratching the passenger side of her front and rear door panels. Then she told the officers that you continued to damage her 2 other vehicles that she owned. Then she said approximately 4 a.m. that there was a witness that said they saw you by his vehicle. You approached this witness, went to pick her up in the vehicle and drove away. All right. Then subsequent to that, officer says that they were able to see camera footage of this incident. They saw on the camera that you were knocking on the window, went to the vehicle's passenger side, damaged side, caught you down and using a flashlight. Okay. So the officers went ahead and did an investigation. They went ahead and contacted the district attorney's office. Let's see here also. She also provided the officers with a voicemail that was left, that you left on her, looks like on her telephone, even though it was blocked. And the officers heard the voicemail and they heard you say that I'm going to fuck you up. All right. So they contacted the district attorney's office. they went ahead and decided to file charges against you for one, harassment, and two, criminal mischief. And then there was a warrant issued for your arrest. So I noticed that it looks like you went ahead and paid a bond, right? You were arrested on these charges. And then when you were arrested, it looks like you went to jail, went before a magistrate judge. Looks like you were released on a personal bond on your harassment and a personal bond on your criminal mischief. Okay, so what we're going to do this morning is, of course, going to issue some conditions regarding your bond. So, Ms. Anthony, do you see this case, Jackson Bennett?
Yes, Judge.
Do you know if anyone from the state has had any contact with the complaining witness yet?
Yes,
Theo, okay.
Judge. But it looks like they are both Spanish speakers, Judge, so we're waiting on a Spanish speaker to talk to them again.
All right.
She's kind of struggling.
Okay. All right, Mr. Bennett, do you have any relationship with this individual, Andrea Castillo, at this time? All right, so is there any reason for you to speak with that person at this time?
No, sir, nothing whatsoever.
All right, so here's what we're gonna do. So, Ms. Garcia, this is on page 2, Bennett.
Yes, Your Honor.
The court is going to order so that while you're on bond, you'll be prohibited from having any contact with Andrea Castillo. Do not call her, text her, email or Facebook. No contact whatsoever. Do not go over to her residence on Applewhite Drive in Katy. Secondly, the court is going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Yes, ma'am.
He has conditions on the harassment.
Oh, that's right. I do see that.
Would you like to mirror those?
Let me see. Let me look at it. No contact, no going, no weapons. Yeah, let's mirror those. I do see, I'm sorry, Mr. Bennett, whenever you went to jail, you went before a judge, a magistrate judge, and I do see that you got bond conditions on your harassment case. So we're going to issue bond conditions on your criminal mischief because you don't have one. It's going to be exactly the same thing as your other case, okay? Like I mentioned, don't violate any of the conditions. If you do, this court can revoke your bond and put you into custody. Now, you're going to need an attorney, sir, to represent you on both these cases. There's two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you one this morning?
I'll take one.
You qualify for one, sir. I'll appoint you an attorney this morning. All right, Mr. Bennett, do you have any questions on anything that I mentioned to you, sir? All right, right behind you at the table to your right, and my pretrial officer, go with her, signs conditions. Have a seat. I'll appoint your lawyer, okay? Thank you. Millie? Page 2, Jackson Bennett, court appoint 2 cases. Give me one second. I'll do one quick Spanish speaker before I lose her. Come on. Ricardo Torres Zuniga. He's got a lawyer, but I just didn't make sure this is on a separate case. And Stephanie, this is an MRP, right? Technically, he's still on probation.
Correct, Judge.
And you need to see him. Okay. And was the motion to revoke as a result of his other case? Yep. I see. Okay, so you are Ricardo Torres Zuniga?
Yes.
All right, Mr. Zuniga, you are here today in reference to your driving while intoxicated case in which you are currently on probation. You were given a probation on this case back on June 20th of 2024. And you were given a probation, let's see here. For a period of 12 months. All right, so I noticed that while you were on probation, you were also ordered to go to a special court called sober court. But I do see that you have another case of driving while intoxicated that was alleged to have occurred on April 26th of this year. On that case, sir, you were arrested, you posted a bond, and we appointed you an attorney, Mr. Casanova. And that case was rescheduled to June the 5th. When you were here last time in court, when we rescheduled your case, the state went ahead and filed a motion to revoke your probation that you're on for DWI. That was filed on May the 1st. So you were on bond for the probation that Mr. Casanova was representing you, and while you were there, they went ahead and filed. Have Mr. Casanova appointed to represent you on your other case? Do you want the court to appoint Mr. Casanova to represent you on this case? Yes, and he can handle both. Okay, sir, I'm going to appoint you, Mr. Casanova. I'm not sure if he's here today, but we'll find out. In the meantime, you are still on probation. You're going to meet with my probation officer this morning because she needs to get some information from you. Once you speak to her, just have a seat and we will appoint you, Mr. Casanova. All right, so any questions? All right, so right here, step over here to my probation officer, Stephanie. So he's coming with you. Talk to her and then have a seat after you finish, okay? All right, thank you, sir. All right, Millie, page 26, Torres Zuniga, court appoint, and it's going to be Edward Casanova because that's who he has previously. Okay, come on up, Mr. Sapien. Good morning. What you got this morning?
Plea on Pinkowski.
Oh, thank you. All right, let me see that. Pull it up. Ben, good?
Good, yes, sir.
All right, right here. All right, let's call her up. Sandra Pinkowski. And are you ready on this? Okay, thank
And
you.
then Judge, on this one?
Yes,
The state forgot to put the DWI education course, so maybe you please add it.
DW Education, got it. All right, and you are Sandra Lee Pinkowski. Hi, Ms. Pinkowski, you're here with the attorney. You are being charged with the offense of driving while intoxicated. Let me check something here. You were previously convicted of the offense of driving while intoxicated in 2012. So this makes it a driving while intoxicated as a second offender. So that is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. You signed some documents this morning. One of the documents that you sign is entitled Misdemeanor Plea Guilty. That document that you signed says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, you give up all those rights. I understand, man. Now, I do have to advise you that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case. Your case ends today. And the other document that you signed says after today, there's not going to be any more work or investigation done by your attorney or the attorneys for the state. Your case is final today. Do you understand, man?
Yes.
Now, did you sign all of these documents freely and voluntarily?
Yes.
Has anyone forced you to sign any of these documents? And has your attorney answered all of your questions you have regarding your case? All right, Ms. Pinkowski, to the offense of driving while intoxicated, how do you plead, guilty or not guilty? Are you pleading guilty because you are? And is it true that you were convicted of the offense of driving while intoxicated in 2012? All right. Ms. Pinkowski, on your plea of guilty, the court finds you guilty of the offense of driving while intoxicated, assesses your punishment at 1 year in the county jail. However, it will be probated for a period of 16 months. You'll be placed on probation for 16 months. Conditions at probation, you're to enroll and complete an effective decision-making course. You're to enroll and complete 2 victim impact panel courses. And Stephanie, is the DWA repeat offenders or just a regular one?
It's up to you, Judge.
No.
Technically, it's the second.
Yeah, so it's gonna be the first one then.
So DWI.
Education. So you are also going to be required to enroll and complete a DWI education course. You're going to do what's called a TRAS evaluation. You're going to undergo random urine test. You cannot refuse any of those tests. You'll be prohibited from drinking any alcohol or any controlled substance not have a prescription for. And you're going to be required to have a guardian interlocked in any vehicle that you drive. Now, because this is a conviction on a driving while intoxicated case as a second offender, the law requires me to suspend your license. So your license will be suspended for a period of 90 days. Now, do you know, Mr. Sapien, that she had an ALR suspension? Did you? When you first got arrested, okay. So what I'm going to do is I'm going to make a request to the Texas Department of Public Safety to give you credit for that time that your license was suspended when you first got arrested on this charge. If everything works out, then your license should not be suspended. But I would definitely check with the Texas Department of Public Safety to make sure that they went ahead and do that, okay? But I am going to make a request for them not to, or to give you credit, okay? I have to suspend it by law, but I'm going to make a request for them to give you credit for those 6 months. So hopefully if everything works out, your license will not be suspended, okay? Now, Ms. Pinkowski, these conditions of probation are going to remain for the next 16 months. If you successfully complete all of your conditions of this probation at the end of 16 months, this case is over. However, if you fail to complete any condition as probation, the state may file a motion to revoke that probation, and you can be sentenced to up to 1 year in the county jail. You're going to meet with my probation officer this morning. She's going to go over with you all your conditions of probation. If you have any questions, ma'am, please ask. Do you have any questions of me?
I do.
Yes, sir.
So, they had reduced it down to avoid the condition. Just want to make sure that's.
Well, it says here that she's pleading true to the enhancements.
The girl.
That leads me to believe
It says
she's.
first read the paperwork, but then it says the range different, so.
All right, so.
She did that, she went and did all the A classes.
All right, so state is on this case, I see on the plea papers, defendant will plead true to the enhancement paragraph. So if that's the case, that makes it a second, but it's pled as a, on the plea papers, it's pled as a first. So I need to know which is it.
Okay, then we can abandon the enhancement, Your Honor.
All right. Y'all need to be careful when you do this paperwork, okay? Because, this kind of messes things up. So if you plan on abandoning, just make sure you put that in the plea papers. You have to be very careful when you do this, okay?
You send it to a DWI first, class A.
It is. It's a DWF first class A, yes. Okay, but the plea paper says defendant will plead true to the enhancement paragraph. If that stays on it, that makes it a second. So that's why I need to make sure you are very careful when you do to make sure that if you're going to abandon it, please put it on there. Okay, thanks.
I'm sorry, I didn't see that.
Yeah, I just noticed that.
I should have.
Okay, so I'll go ahead and hang on. I'm just gonna.
Be much closer. I know you need an
Yeah,
estimate.
because she's not giving us the number.
Okay.
Or we could just do a time served on it.
What our prior history looks like, Kel.
It's
My thing I'm pulling up here.
pending injury to a child, and then she's got a theft that was dismissed from.
All right, so then, actually, Ms. Pentowski, you're being charged with the offense of driving while intoxicated as a first offender, okay? It's a Class A misdemeanor, but I'm still gonna go ahead and give you credit for your suspension, so they should not suspend your license. Now, like I mentioned, you're gonna meet with my probation officer this morning. So do you have any questions, ma'am? No. Any other questions, Mr.
There's no issue with the mandatory fines. I didn't hear you mention that.
No, do you want this to be waived?
Yes, Your Honor.
This is my last copy. Go ahead and, just fill that out. It's okay, I can get some more. And just turn in to the clerk, Ms. Seppian, and I'll make sure I waive those fees. All right, ma'am, if you would just step right here, and good luck to you, ma'am. Thank you. Yes, ma'am. No, you know what? No, because it's a first.
Okay.
Did she, I don't know what she got on her first DWI, but I guess it doesn't matter. It's over 10 years old. So no suspension. Yes. Ay.
You don't need more. No, I'm trying to see if this like this.
No, it's time servers for your
Like, yeah,
possession.
you allow this.
Miranda.
Wait, do you? I'll just make a note.
Mr. Morales, can you hear me? Yes, sir, I can hear you. Good morning. Thanks for your patience. What you got this morning?
I'm here on Jason Pena, Your Honor. This is our second
Pena?
appearance.
All right, give me 1 second here. Let me pull it up. Oh, yeah, I see it right here. Are you still waiting for discovery from the state?
We actually just got the blood results a couple of days ago, so I just received those. So I'm just asking for a reset.
No worries. I don't mind giving you a reset. So give me 1 second. Let's see here. Millie, page 20, Jason Pena. I just need a 30-day reset. This is a second appearance. He just received discovery. Or another reset. Doesn't have to be 30 days.
Okay, Judge, July 8th.
Mr. Morales, July 8th, is that a good day for you?
That'll work, Your Honor.
All right, July 8th, and your client's appearance is waived.
Okay, thank you very much.
You got it. Take care. Thank you.
You too. Bye.
Bye-bye now. All right, let's see here. Okay, let's see who else I have. Yes, ma'am. Oh, thanks. I was going to print them right now, but thanks. I appreciate it. Okay, let's see who's next. Blaine Mechie.
Yes, sir. How you doing, sir? Not bad.
How you doing, sir? Take your time. It's okay. Your Blaine, is it Mechie? Mesh. Thank you. Okay. All right, Ms. Mesh, you do not have a lawyer today, right? All right, Mr. Mesh, I just wanted to inform you, sir, of what you are being charged with. You're being charged with the offense of terroristic threat. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. I see that this was an offense that was alleged to have occurred April the 30th of this year. There's an individual by the name of Timothy Mesh that's accusing you of this offense.
Oh, yeah.
Notice that you were on this charge. You did go to jail. You went before a magistrate judge at the jail. You were released on a personal bond, but I noticed that the magistrate judge went ahead and signed 2 court orders, which I have to believe you have a copy of. The first one that I see is called a protective order. That's okay. You don't have to show that. Just make sure I just want to kind of let you know that the first one that I see is what's called a protective order. That is a court order, sir. So if you violate any of the conditions of that protective order, you're subject to having the state file an additional charge, which carries a 1-year jail sentence. I also see that the magistrate judge went ahead and signed some bond conditions, some conditions in reference to your bond. That is also a court order. And if you violate any of those conditions of bond, you're subject to having the bond that you're currently on revoked and you can be taken to custody. Now, let me get with the state on something. Miss Anthony, do you see this case?
Yes, Judge.
Do you see if anyone from the state has had any contact with the complaining witness?
Yes, we have, Judge.
And is the complaining witness making any requests for anything specific?
Yes, they would like to lift the residency restriction and they're okay with no threatening, harassing.
All right, I do see the residency restriction on the bond conditions and the MOAB. All right, so let me do that. And I know I also saw a GPS mark,
You already has it.
but I don't know why.
Yeah, that was the magistrate judge.
I know, Miss Anthony.
Yes, Judge.
Let me hear on this case.
Yes, Judge. Complainant is defendant's father. On 4/30/2025, officer was dispatched in reference to a weapons disturbance. The call note stated, son is threatening to cut his throat, screaming upstairs. Officer detained defendant and patted down, no weapons were located. The witness, who was defendant's mother, stated she received several texts, including, I'm scared I'll kill him. I mean, I might kill him. No one could stop me. I would put it on a pike out front. Complainant advised he was in fear for his life and feared the defendant would hurt him or the witness at some point due to the threats made.
And so since then, the complaining witness is requesting to lift the residency restriction.
Yes, Judge.
Okay. Let's see. On page 17, mesh. Can you print me out the MOAB? I need to amend it. And let's amend the conditions, Ms. Garcia.
Yes,
All right, here's what we're gonna do, sir. Because the state has had contact with your father and he's requesting that he does not want a restriction on residency, I'm going to remove that. I'm gonna go ahead. Yes, and give me 1 second though. I'm gonna remove the residency restriction on the protective order. So that way you will have the ability, if you want, to go to that residence. Now, were you residing with your father when this happened? Are you still going, once this is lifted, you're gonna go back?
Yes, sir.
All right, so you will be allowed to go back to the residence in Humble, on Tree Moss Place in Humble. So I'm gonna do that right now, so that I'm gonna go ahead and make sure you're welcome. I'm gonna make sure that I remove that. That will be removed. So now you have the opportunity to go back to that residence. Now, I'm also going to remove on your protective order, because you were also ordered not to have any contact. I'm going to remove that too. So that way you can have contact with your father. Now, however, you are not to have any threatening, harassing, or you cannot assault your father. You may have contact with your father, you can communicate, live with him, etc. Just do not harass him, threaten him, or assault him. Now, on the conditions of bond, oh, is that not the order? Oh, okay, that's okay. But I can still use, well, I better not. On your conditions of bond, you also had a residency restriction. So you also were given bond conditions that says you are prohibited from going to residence. I'm going to go ahead and change that. So my officer in court this morning, Ms. Garcia, is going to amend those conditions. We're going to change it. We're going to remove the residency restriction, but you are still ordered not to threaten, harass, or assault your father. You're still ordered not to have possess any firearms or any weapons. There's another person that they listed for you not to threaten, harass, or assault, and that's a Cynthia Mesh. All right, so I'm going to keep that too. So do not threaten, harass, or assault Timothy and Cynthia Mesh. I'll remove the residency restriction, and I'm going to go ahead and remove your ankle monitor. So let's remove the GPS ankle monitor. Because there's,
Travel restriction as well?
oh, really?
Yes, Your Honor.
Let's remove that too. So I'm going to go ahead, because I do see that the magistrate judge went ahead and issued a restriction on travel. I'm going to remove that. I'm going to remove your ankle monitor, and I'm going to remove the restrictions of you going back to that residence, okay? Now, you're welcome. My pretrial officer is going and amending those conditions. So in a couple of minutes, I do need for you to go over with her to sign those amended conditions. I do have to remind you, sir, that if you violate any of those conditions, a bond, you're subject to having the court revoke your bond and you can be taken into custody. Now, having said all of this, sir, you're going to need an attorney to represent you on this case. Would you like the court to appoint you one this morning? I will appoint you an attorney this morning, sir. All right, you're welcome. Mr. Mesh, do you have any questions on anything that I mentioned to you, sir?
It's not that I could think of.
Okay. I will appoint you a lawyer this morning. If you do have any questions, just speak to the attorney that's gonna meet with you this morning. Let your attorney kind of advise you of what the best course is regarding this case, okay? All right. Right to your right at the table of my pretrial officer, go with her, signs conditions, have a seat. I will appoint you a lawyer, okay? You're welcome. Millie?
Yes, Judge.
On page 17, Blaine Mesh, court appoint. Give me 1 second. Let me do this real quick. Okay, there you go. Yes, sir. Coming up. Good morning. How are you?
That's good.
What you got this morning? Tiara mattress.
Filed yesterday.
Okay, give me 1 second. Well, let me see here. Let me pull it up. Interesting. I don't see it. Let me look at it real quick. Did you, Ed? I was gonna say, did they email you something? Let me look at it. Oh, you know what? I hadn't signed it yet. But let me look at it. I can sign it right now. Let's see. Oh, I need to talk to her. She's here?
She is here.
All right, let me do this just so that I can make sure everything flows smoothly. Let me just go ahead and sign that bond violation report. She's here anyway. We'll talk about it. Were you able to see what it was?
Yeah, you had a couple of high racks.
Same amount of days he's got 44 days. Same as the other. Appreciate it.
High racks, and then the skip tests were because of some scheduling that she's starting with a new job. So she hadn't quite gotten the scheduling down.
All right, look at real quick. I do see, and you have this up, Ms. Garcia, the BVR on Mathis. This is on Mathis. I just signed it. Oh, I don't know. I do see it. It says here, let's see, 426 blue. All right. Were you able to read the bond violation report?
Yes, sir.
It says on April 26, she took a breath test and the results were 0.13. Now, that doesn't sound like Listerine because that is indicated of being over the legal limit for intoxication.
Yeah.
And that's April 26th, a Saturday evening
44 times 3.
at 7:03.
Although it's 7:10, 7 minutes later,
Yeah.
it went down to a 0.065.
Yeah, I know.
It's physically impossible. To go that quickly from a 0.13 to a 0.065, so. it's
And then-
you know,
And then, but then 12 minutes later, it's still a 0.065.
And then it's and then 7 minutes later again, it's going down.
Yeah,
And then 3 hours later, it's 0.03.
right. All right, so I'm sure you're aware a Listerine would not cause that kind of, it has to be alcohol.
She's telling me that she was not drinking. I understand. I can only tell you what she's.
I know, I understand, but that's the reason we ask people to blow again, kind of confirm. Then I also see on 429, yeah, same thing. Two tests, both 0.037, and then another one that went up instead of down. Okay, all right, she's here. Let's call her Tiara Mathis. You just got a pointer, right? Not too long ago?
Yes, January 11th.
Yeah, I see it. All right, man, you are Tiara Mathis. Miss Mathis, you're here with your attorney. You're here because I received a report from pretrial services in reference to your interlock device. What I see is that you are required to blow on your machine, and you did. But I do see that when you blew on your machine, there was an indication of a positive test for alcohol. Specifically, ma'am, what I see is that on April 26 at 7:03 p.m., when you blew on your device, it tested alcohol, positive for alcohol on your breath. The amount that I see that was tested is a 0.131. Now, your attorney has mentioned to me that you had mentioned to him that you believe that this was a result of you taking some Listerine or something like that. Okay, now I do know that Listerine, some mouthwashes contain alcohol. And then if you happen to take that and blow, it's going to test positive for alcohol. However, I do have to let you know this, Miss Mathis, the amount that this machine registered of 0.13 is above the legal limit that the state of Texas imposes for intoxication. So when I see this, just by looking at it on paper, this indicates to me that you were intoxicated legally under the laws of our state. Now, you're required to blow again, which you did, and I appreciate that you did that. And the reason that we ask you to blow again is we want to make sure that this was not a false positive test, that, it was accurate. The next time that you blew was at 7:10, which is 7 minutes later, but it went down to 0.065, still alcohol. Then you blew again at 7:22. It was once again 0.065 alcohol, 7:29. Once again, 0.63 alcohol, 10:04, still 0.003. Now, let me tell you, Ms. Mathis, what this tells me just by looking at it on paper, okay? It is not possible that these results are because of mouthwash. Mouthwash has a very low amount of alcohol, very low. No, don't say anything. Don't say anything. Very low amount, okay? The amounts that the machine registers indicates on paper that you were drinking alcohol. That's the reason we ask you to blow again, because this is a way for us to determine, or the machine to determine, whether it was alcohol from an alcoholic beverage or something else. If you are saying to your attorney that you drank or consumed Listerine, You must have consumed 5 gallons of it in order for it to reach that level. There's no way that Listerine would cause a reading of 0.13. That is above the legal limit in Texas for you to be intoxicated. Now, you don't have to say anything. I'm not asking you to say anything because I don't want you to admit anything or anything. Your lawyer, I'm sure, will tell you that. Okay, I'm just letting you know this is what I determine when I see this on paper. Okay, now, secondly, I also see that you went ahead on a different date, Blue, on April the 29th. April 29th was a Tuesday at 10:39, and you had an alcohol reading on your machine of 0.037. You blew again at 10:44, and on this one, the alcohol concentration went up. It did not go down, it went up. You had 0.37 at 10:39, and you had 0.48 at 10:44. It went up. Okay. Once again, just by looking at this on paper, this leads me to believe that you were drinking alcohol. Okay, that's the only other thing that we can think of. Now, your attorney can request the full report, and we can make sure if it's alcohol or not. Okay, and I can request the full test to see, but I really don't want to do that because these machines are pretty accurate. Okay. Now, the other thing that I want to address is that I do see that you have missed some tests. I'm not too concerned with that. Okay. Sometimes I understand why you miss tests. You have to blow 3 times, and sometimes you may blow outside your time period. That's considered a skip. Sometimes you get caught up, you forget. I can excuse you for those. It's not that many, 9. But it's going to be really difficult for me to excuse you when I see those positive tests. Okay, it really is. I'm just being perfectly honest with you. You are prohibited under your conditions of bond from drinking alcohol. And this violation could result in this court revoking your bond and putting you into custody this morning. Do you understand that? And I assume you do not want to do that. Your attorney doesn't want me to do that. And I've known him for many years. And I know he doesn't want me to do that. And honestly, Ms. Mathis, I do not want to do that either. I don't like revoking bonds and putting someone into custody. I don't like doing that. So I see that this looks like it's your first violation. So here's what we're going to do. I'm just going to give you a warning. Okay, Ms. Mathis? This is a warning. After today, I do not want to see another test that indicates positive for alcohol on your breath. Because if I do, and especially if I see something like this, the results, I will probably revoke your bond and put you into custody. And you're going to stay there until this case is over with. And if that happens, I know for a fact you're not going to be drinking in jail. Okay? All right. And I also, please try not to miss a test.
Okay.
All right. And Ms. Garcia, this is on Mathis. Does she have UAs?
No, Your Honor, she doesn't.
Oh, okay. Let me see. Oh, dude, I did these orders. I wonder why I didn't do UAs. All right. Well, I'm going to leave it alone then. All right, Ms. Mathis, do you have any questions on anything that I mentioned to you?
Well, is it no way that I can change like the hours?
All right. Are you having issues with blowing on certain time periods?
Yes, sir.
What specifically, do you know what time periods that you're having issues with?
I work from, some days I work like from 1 p.m. to 11 p.m.
Okay, 1 p.m. to 11 p.m.
And 4 p.m. to 2 a.m.
Oh, I see.
4 p.m. and 2 a.m.
All right, so have you missed your test in the morning? You have a 5 a.m. to 8 a.m. Okay, then you have another one from 5 p.m. to 8 p.m. Is that where you're having problems with? No? Are you having problems with the 10 p.m. to midnight? And is that because of your work, because you're working?
Yes.
Do you take your machine with you to work?
But, we sometimes like extra crowded. I'm a cashier.
Mm.
So when, people are coming in, they won't let me do the register. I can't go right there.
Yeah, and you shouldn't blow in front of everybody. It's just something private. You know, I want you to go somewhere where no one can see you blowing a machine. You work where? What type of work do you do?
I'm a swing worker. It's a restaurant.
Okay. And if you work late, what hours do you work late?
Those are, 4 p.m. to 2 a.m.
Oh, I see. So that 10 p.m. to 12 a.m. is what's hard for you. You don't have any problem with the 5 p.m. to 8 p.m. Okay, so you can blow during that time period.
Mm-hmm. We get busy. We get busy like around 7 o'clock.
Oh, okay. And then in the morning, if you work late, you say what time to 2 a.m.? Sometimes?
Yeah, 2 a.m. in the morning, but I still could blow early in the morning.
So you don't have no problems with blowing early in the morning then? Even though, even if you get out so.
I have to wait for the second my daughter.
Oh, okay. All right, so let's do this then. When you get out at 2 a.m., what time do you usually get home? Oh, so you don't work far from, and when you don't work till 2, what hours do you usually work? When you don't work till 2, what time would you get off?
At 11 p.m.
At 11, okay. Well, damn, I'm trying to think of a way we can resolve this. I mean, I could switch it to you blowing after you get out of work on your late shift, but then I know. So, all right, so 10 to 2. Do you think if I give you extend it an additional hour that will help from instead of 10 to midnight, 10 to 1?
Yes.
Or from 11 to 2? Would that help? That would be okay. So Ms. Garcia, let's amend it.
Yes, Your Honor.
Let's amend her conditions on her last blow. Let's change it to 11 p.m. to 1 a.m. Did you say 1 or 2?
11 to 2.
10 to 1.
That's fine with me. 10 to 1.
Okay.
You tell me. You got to tell me, okay? Because
Because some days I get off early.
okay, I don't want to change it, and then you're having problems. So then you want me to 10 p.m. to 1 a.m.? Okay, so let's do that. 10 p.m. to 1 a.m. Okay, Ms. Mathis, I want to help you out. Okay, changing the time periods is not an issue. The issue that I have is if you're drinking. That's the problem that I'm going to have. Okay. Yes, ma'am. Good.
I see she has a verbal guide, and she's allowed to drive. I don't know.
Oh, really? Let me look at it. Okay. Yeah. Well, you cannot drive a motor vehicle if you have a portable device. Yes, exactly. If you have it on your vehicle.
Okay.
So do you want to have an interlock in your vehicle or do you have? Okay, so you can't drive. So let's submit. So we have to put also orders, no driving. Okay, no driving at all. So we're going to change the orders, change the time, and we're also going to put no driving. If you decide in the future, if you get a car and you do want to drive, just contact your attorney. You can switch the orders just like we're doing this morning. Okay?
And one more question, so I have a violation, a restriction on my license right now?
Talk to you, I don't know. Yeah, talk to you. I can't answer that question. Yes. Yes, so I can't answer that question. All right. Anything else, Ms. Mathis?
No, sir.
All right. Right behind you is my pretrial officer. Go with her, signs conditions, have a seat, and we'll just reset the case.
Thank you, Judge.
You're welcome. Yes, sir. Okay, you're back.
Yeah, I'm back on Roberts.
She here?
She is, Judge. She's, Ms. Roberts, just raise your hand.
Come on up, Ms. Roberts. Did she get reset?
She did, Judge.
Okay.
She went up to felony court. They've got her coming back Thursday you want me over here? I let you tell them.
On Thursday? What?
They've got her coming back Thursday in felony court. The interlock is scheduled, the installment is scheduled today, or the machine being at the location is scheduled today?
The device is being shipped to the location today.
Do you know which company that you're getting the device from? They usually have them in stock.
I had an appointment set whenever I got out, when I got on. It was on back order, so I had an appointment for April 25th. I showed up and I spoke to Abraham who worked there. My device wasn't in stock. He said just to wait until, they emailed me the tracking number. I never got it. So all week I've been blowing them up, calling, and that they said yesterday that the tracking was coming today. And I've been looking at the tracking number.
So they told you he's going to be in.
What we had discussed.
Yeah, I know. And they told you that it's going to be in when? Today? All right, so and you're going to pick it up when? Today?
It said online by around 3 p.m. I should be there.
Can you do that?
Yes.
Okay. All right, no worries. So we're good. You see, I wanted to address because I noticed that you hadn't got your machine and we've been waiting for you to get it for a while. Okay, to make sure you get your machine, make sure that they're going to give you instructions on how to use that machine. You have to blow 3 times a day. Make sure that you write down the hours, because I don't want you to miss those hours, and you have to blow every time during those hours. And secondly, no alcohol whatsoever in your breath. Okay. All right. So do we need to amend her conditions? This is on Roberts. She's getting she's picking up her machine today.
No, Your Honor.
Okay. All right. So make sure that you pick it up and make sure you blow and make sure no alcohol. Okay. Because if I receive a report saying that you forgot to blow during time periods or alcohol, you're going to come back and see me. All right. All right. Any questions? All right. Just have a seat and then we'll reset the case.
Thank you, Judge.
You're welcome. Thank you.
As far as the setting,
Oh, yeah. It's
we're following the felony.
That's up to you if you want to. Does she have to be here?
You'll have to be here Thursday for the felony.
Really?
If you're okay with it, we can push it out.
We can push it out. Are you still trying to work out a deal? A global? Okay. That's fine.
Confirm with that.
No worries. We can do it after the felony.
Thank you.
You're welcome. Yes, sir. Hey, Mr. Sims.
Good morning, Your Honor.
What you got this morning?
I have an off-docket plea, Mr. Williams.
Oh, a plea. Okay, give me 1 second here. Williams, Robert Williams?
Yes.
All right, let's call him up. Robert Williams? One second. All right, so you are Robert Williams?
Yes, sir.
Mr. Williams, you're here with the attorney, Mr. Sims. You're being charged with the offense of driving while intoxicated. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. You signed some documents this morning. One of the documents that you signed, sir, is entitled Misdemeanor Plea of Guilty. That document, sir, says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, sir, you give up all of those rights. Do you understand, sir?
Yes, sir.
Now, Mr. Williams, I do have to advise you that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admission to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case. Your case ends today. And the other document that you signed says after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your case is filed today. Do you understand, sir?
Yes, sir.
Mr. Williams, did you sign all of these documents freely and voluntarily?
Yes.
Has anyone forced you to sign any of these documents? And has your attorney, Mr. Sims, answered all your questions you have regarding your case?
Yes, he has.
Mr. Williams, to the offense of driving while intoxicated, how do you plead? Guilty or not guilty? Are you pleading guilty because you are?
Yes.
Mr. Williams, on your plea of guilty, the court finds you guilty of the offense of driving while intoxicated, assesses your punishment as per the plea agreement at 3 days in the county jail. You'll be given credit for 1 day that you've already served. That's time served, no more jail time. Any court costs that you might owe to the county, I'm going to run it concurrent with your time, which means that you will not have to pay any money to the county. However, as a result of this conviction, there will be a suspension of your driver's license for a period of 90 days. All right, sir, do you have any questions on anything that I mentioned to you, sir?
You know, I can run that, suspension is current with his current suspension.
Does he have an ALR suspension?
Yes, sir.
Okay, I can't run a concurrent. I just, the DPS requires me to ask for credit.
Okay.
So I'm going to ask DPS to give him credit. Okay, so Mr. Williams, I'm going to make a request to the Texas Department of Public Safety to give you credit for the time period that your license is suspended as a result of this arrest toward this suspension. If everything works out okay, your license should not be suspended as a result of this conviction. Yes, sir. Anything else, Mr. Sims?
Yes, sir. I would also like to take my client on fixed income. He was allowed to the agency pay for his device.
Yes.
On an extra surcharge be waived.
Oh, yeah. Let me give you that form. And if you don't mind, Mr. Sims, just please fill that out, turn it into my clerk, and I'll waive all those fees too.
Thank you.
You're welcome. All right, sir, if you would step right here to my left, and good luck to you, sir. You're welcome. PC ALR, yes, sir. ALR credit. Yes, ma'am. How are you?
Things good. How are you?
I'm good, thank you. What you got this morning?
Andrew Lara for another plea judge.
1 second.
Oh. When I credit, I start doing it.
Yeah, right here. Let's bring him up. Andrew Lara. I've got 2 cases. Is the weapons case being dismissed?
Yes.
Okay. All right, so you are Andrew Lara?
Yes.
Mr. Lara, you're being charged with 2 offenses. You're being charged with the offense of unlawfully carrying a weapon, and you're being charged with the offense of driving while intoxicated. The state is dismissing your unlawfully carrying a weapons case, and we're going to resolve your driving while intoxicated case. So, Mr. Lara, you're charged with the offense of driving while intoxicated. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. You signed some documents this morning. One of the documents that you signed, sir, is entitled Misdemeanor Plea of Guilty. That document, sir, says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, sir, you give up all of those rights. Do you understand?
Yes, sir.
Now, I do have to advise you, sir, that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case. Your case is final today. And the other document that you signed, sir, says after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your case ends today. Do you understand?
Yes, sir.
Mr. Lara, did you sign all of these documents freely and voluntarily?
Yes, sir.
Has anyone forced you to sign any of these documents?
No.
And has your attorney answered all your questions you have regarding your case?
Yes, sir.
Mr. Lara, to the offense of driving while intoxicated, how do you plead, guilty or not guilty? Are you pleading guilty because you are?
Yes, sir.
Mr. Lara, on your plea of guilty, the court finds you guilty of the offense of driving while intoxicated, assesses your punishment at 6 days in the county jail. You will be given credit for 2 days that you've already served. That's time served, no more jail time. Any court costs that you might owe to the county, I'm going to run it concurrent with your time, which means that you will not have to pay any money to the county. However, as a result of this conviction, there will be a suspension of your driver's license for a period of 90 days. All right, sir, do you have any questions on anything that I mentioned to you?
Judge, if
Yes.
I may, can we ask for credit for his ALR suspension that he had?
Yes, did he get AL suspension?
Yes.
Okay.
Last year.
Oh, no worries. All right, Mr. Lau, I'm going to make a request to the Texas Department of Public Safety to give you credit for the time period that your license was suspended as a result of this arrest. So hopefully, if everything works out okay, your license will not be suspended. All right, any other questions? All right, sir, if you would step right here to my left, and good luck to you. Thank you.
Judge.
You're welcome. Thank you. Yes, ma'am. Who's next? Come on up. Hi, good morning. How are you?
Good morning, Lacey Johnson with the DA's office, Judge. I'm
You,
from,
Ms. Valdez. Yes, Ms. Johnson.
I am here from the Mental Health Division, and we
Yes.
are here on Mr. Lok Chung Chu. I can give you a case number.
Is he in custody?
He is.
Is it on the docket today?
I
Or
believe it's on docket, sir.
is that Chu with a C?
With a T-I-E.
T, oh, let me see. Let me look at my jail docket. Well, you know what? I don't see it. So yeah, it is. Okay, give me the case number.
Yes, sir. It's 2552770. He has two cases. A theft and a trespass. So earlier this week, his appointed counsel filed a motion for competency exam. And the long story short is that Mr. Chu is presumed incompetent under Manning v. State because his last felony case, he was found incompetent to stand trial. He was sent to a hospital for competency restoration services and was found not competent, unlikely to restore. So the state dismissed the charges.
The robbery case?
Yes, sir.
I see that.
Yes, sir. So
Oh.
instead of waiting for another competency exam and all that, what the state is requesting is that the court enter an order transferring his cases for civil commitment, and then I'm happy to dismiss all the charges.
Okay, so I need a court directive, right? Making a request to transfer him to, I guess, civil commitment. Was he civilly committed in felony court once he was found incompetent, or?
No, so what happened is we entered the order for competency restoration, the 073 order. And then pursuant to that order, he was sent to, I believe it was, let me double check. I believe it was the Dunn Center here in Houston.
Okay.
Yes, that's correct. And then he received competency restoration services there. At the end of that commitment period, they said that he is still incompetent and unlikely to restore. So we arranged placement for him in a personal care home. And once we got him placed, we dismissed the case rather than, keeping it pending. I had emailed the clerk yesterday, and hopefully it's in your queue. There is an order transferring for civil commitment. I had let them know which boxes to check. And then they tell me that upon the entry of the dismissal, they have their SOPs with the directive to hold for civil commitment.
I do see it. I do see, and the boxes were checked is pursuant to Article 46B.004C.
It should be E. Yes.
Let's see. Oh, well, I have here that was checked was the second box.
Yes, the second box is correct. It looks a little fuzzy, but it should say E, but those parentheses overlap it.
And then the findings, the defendant was found incompetent in his or her most recent matter, and the cause was dismissed. I see it.
Yes, sir.
Okay, so I can sign that order, and then the court orders, you have the person to be held in the Harris County Jail pending prompt transfer to the mental health facility. Mental health as Harris County Probate Court number 3 may direct. Okay. So that's what you want me to sign. Okay.
Yes, sir.
And then that will allow the state to dismiss the two cases, and that will allow him to be transferred.
Yes, sir.
Got it. So let me go ahead and do that right now. Sign that order. Now, you still, the state still needs to dismiss the cases though, right?
Yes, sir. And I'm filing those now. I just like to make sure that you've had a chance to rule on that request before I file those, so there's no mix up.
Thank you.
Thank you, Judge.
You're very welcome. Okay, so hopefully he'll be able to go, and I'm hoping that he'll be restored.
Yeah,
So-
well, the thing that I kind of tell civilians when they ask me what I do is like, someone may not be competent to stand trial, but they can be competent to conduct their day-to-day affairs. And so what I'm hoping for is that they'll get him his medication and get him connected to services, and hopefully he won't come back, but we'll see.
Okay, all right, I signed it, you got it.
Thank you
As
so
soon as
much,
I get
Judge.
those dismissals, I'll sign them too.
Thank you,
All
sir.
right, you're welcome.
Right now.
Thank you. Yes, ma'am, good morning.
Good morning, Judge.
How are you?
How are you doing?
I'm good, thanks. What you got this morning?
Representing Curtis Stafford.
Okay, so plea?
Right now, he's elected to take a plea.
No worries.
On his charge.
All right, let me give you 1 second while I pull this up. Oops, I don't have it yet. No worries. Oh, here it is, Stafford. All right, sir, you are Curtis Stafford?
Yes.
Mr. Stafford, you are charged with the offense of assault of a family member. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. You signed some documents this morning. One of the documents that you signed is entitled Misdemeanor Plea of Guilty. That document, sir, says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, sir, you give up all of those rights. Do you understand? You have to answer up.
Yes.
Okay, thank you. Now, Mr. Stafford, I do have to advise you that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case. Your case ends today. And the other document that you signed, sirs, is after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your case ends today. Do you understand? Yes. Okay, thank you. Mr. Stafford, did you sign all of these documents freely and voluntarily?
Yes.
Has anyone forced you to sign any of these documents?
No.
And has your attorney answered all of your questions that you have regarding your case?
Yes.
Mr. Stafford, to the offense of assault of a family member, how do you plead? Guilty or not guilty? Are you pleading guilty because you are? Mr. Stafford, on you plead guilty, the court finds you guilty of the offense of assault of a family member, assesses your punishment at 21 days in the county jail. You will be given credit for 7 days that you've already served. That is time served, no more jail time. Any court costs that you might owe to the county, I'm going to run it concurrent with your time, which means that you will not have to pay any money to the county. All right, Mr. Stafford, do you have any questions on anything that I mentioned to you? I do have to mention one more thing. As a result of this conviction, there will be an affirmative finding that this case involved family violence. What that means is that if you get arrested again in the future, and charged with the offense of assault of a family member, that becomes a 3rd-degree felony, and you could be sentenced to up to 10 years in prison. All right, sir. If you would, any questions?
No, you're
Mr. Stanford, good luck to you, sir. Thank you. You're welcome. Thank you. You're welcome. Yes, sir. Yes, sir. Come on up. Buenos días. ¿Cómo estás?
Muy bien. Ustedes.
I'm good. Aquí nomás. What you got this morning?
Judge, I'm approaching us Sabrina Hadnot, this docket, and it's on emotional withdrawal on both of her causes.
Is she on the document? What's her last name? Oh, yeah, I saw that this morning. All right, let me call her name. If she's not here, then what we're gonna do, Sabrina Hadnot. All right, so since she did not answer, I'm going to revoke her bond. And did you e-file your motion to withdraw?
I did, Judge.
Let me see.
I was appointed to her, I was appointed to 2 separate death cases. Motions to withdraw were filed on both of those
Yeah,
copies.
I do see 2 thefts and don't see them on my queue. Oh, I see them now. Okay, you got it. I'm signing both of them right now. You got it. Done. Is that all you have? That's all you have to do?
That's it.
Okay, good to see you.
Excuse-
Yes, sir. Thank you. Yes, ma'am. Good morning.
Yes,
Yes, ma'am. Come on up.
Thank you so much. I'm also here on an off docket plea.
Okay. On a plea. Okay, good. Oh, we need an interpreter?
I'm talking to. Oh, sorry.
Okay. Who's it on?
It is on Arthur
Oh,
O'Neill.
yeah, I got it right here. Let me see here. All right, let's call him up. Arthur O'Neill.
Got 2 years student service. It's good.
All right, Monica, do you know how this is O'Neill? Do you know how much credit he has? Okay, thanks. All right, so you are Arthur O'Neill?
Yes, sir.
Mr. O'Neill, you're charged with the offense of driving while intoxicated. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. You signed some documents this morning. One of the documents that you signed, sir, is entitled Misdemeanor Plea of Guilty. That document, sir, says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, sir, you give up all of those rights. Do you understand? Now, Mr. O'Neill, I do have to advise you that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case. Your case ends today. And the other document that you signed says after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your case ends today. Do you understand, sir? Now, Mr. O'Neill, did you sign all of these documents freely and voluntarily? Has anyone forced you to sign any of these documents? And has your attorney answered all of your questions that you have regarding your case? Mr. O'Neill, to the offense of driving while intoxicated, how do you plead, guilty or not guilty? Are you pleading guilty because you are? Mr. O'Neill, on your plea guilty, the court finds you guilty of the offense of driving while intoxicated, assesses your punishment as per the plea agreement at 12 days in the county jail. You will be given credit for, is it 14 days? I'm sorry? 4 days, I'm sorry. You'll be given credit for 4 days that you've already served. That is time served, no more jail time. Any full costs that you might owe to the county, I'm going to run it concurrent with your time, which means that you will not have to pay any money to the county. However, as a result of this conviction, there will be a suspension of your driver's license for a period of 90 days. All right, sir, do you have any questions on anything that I mentioned to you? Does she have any questions?
Judge, if he has ALR credit, would that go towards this?
Yes.
For suspension?
Do you know if he has it?
We believe he does, but I'm not 100%
All
sure.
right, if he does, I will make a request to the Texas Department of Public Safety to give him credit for that ALR suspension. Do you remember if your license was suspended when you first got arrested? I forget.
I got a letter of mail telling me that pay fine.
No worries. So what we're going to do is I'm going to make a request to the Texas Department of Public Safety for them to give you credit on that suspension toward this 90 days. If everything works out, your license should not be suspended. All right, sir. Do you have any questions, Mr. Neal?
Questions?
Yes, Michelle, questions?
One more thing, Judge.
Yes, ma'am.
My client is indigent. I am court appointed. I wanted to see if this would be willing to waive the DPS.
Yes, ma'am. Let me give you this form, and if you don't mind, Ms. Sheehan, just have this form filled out. File it with my clerk. Thank you. And I will waive all of those fees.
Perfect. Thank you so much.
You're welcome. All right, sir, if you would step right here on my left, good luck to you, sir. Thank you. Yes, ma'am.
What I'm saying is that we have 16, so we need an interpreter. We requested the interpreter, but they're not here yet, so.
Oh, on Mr. Savedo's case?
There were 2 Spanish speakers.
Oh.
They're in custody.
So we're just waiting.
Yeah, let's just wait for, because, Millie, I'm assuming she,
I did contact with them, but.
oh, so we're just waiting?
Yeah,
I'll just kind of hang tight in Southville.
Go wait here.
Okay. Do you have anything else besides those 2?
Go to court 15, but I could wait for the interpreter a little bit more.
Okay, so we're gonna do, Bruce
Okay.
in the meantime, and then.
Okay.
once they get here-
Thanks, Mr. Savedo. Yes, ma'am, come on up. Yes, ma'am, what you got this morning?
Good morning, Your Honor. I'm here on a matter that is off docket that was set for the 13th. It's a bond violation report.
This number.
The case number is 255 335330.
Whitley, Brian?
You're not doing the plea?
No, I'm not doing a plea.
Oh, this is on Brittany Whitley?
Yes.
Okay. Is that
Oh,
him?
yeah, that is. I am doing a plea, but that's not Mr. Whitley, because I haven't gone over his paperwork with him yet. This is Mr. Freels.
Oh, okay, then.
Yeah, I just did my signature.
Oh, okay.
Yes.
Okay, so you need his signature? Let's do this plea real quick. Let's do, because,
I haven't gone over the paperwork with him.
oh,
I just went, I'm just trying to, multitask while I was standing in line, I did my signatures.
Oh, okay.
And then I was gonna go and do his signatures, but I had Mr. Whitley here, because he has a bond violation report.
Okay, you can just go ahead and address that.
And when I spoke with him, he wanted to address that immediately and not wait until the next
see,
court
when
date.
he just said, oh, he's set for next Tuesday.
Yes.
Let's see what it is real quick.
It's a no.
Oh, I see. It's a no-show. Okay, is he here?
He is here.
Let's bring him up. Brian Whitley? Did you see what it was? He missed his UA?
Yes.
Okay.
And so I.
Well, he's got UAs, and I have to believe that he's being texted every day. Do you see that, Miss Garcia? Is he receiving texts? Okay. Yes, you got this in March. All right, sir. Good morning. You are Brian, is it Whitley?
Yes, sir.
Hi, Mr. Whitley. You're here with the attorney. I just wanted to inform you, sir, that I received a report from pretrial services in reference to a violation of your conditions of bond. Specifically, sir, I see that you were ordered to undergo random urine test. I see that you were given these bond conditions on March the 6th. And I think he didn't report next door.
No, Your Honor.
He didn't report next door. Is he supposed to when he first got, well, when he first got the bond conditions?
I can check, Your Honor.
Okay. Do you remember, Mr. Whitney, when you were here in March and received those conditions of bond, if you went next door to report with pretrial? Do you remember, you know?
No, yeah, see, I was just giving random UAs and no device, he was instructed.
Oh, I see. Gotcha. Okay. Now, Mr. Whitney, you were instructed that you were going to be receiving text messages from the county in reference to a request for you to do a urine test. Have you been receiving those texts? Okay. However, I've been informed that you're not responding to those texts. If you get a text, excuse me, Mr. Whitney, that says you do not have to come and do a urine test, you still need to respond and say, got it. Yes, ma'am.
If I may?
Yes, ma'am.
I'm sorry, Your Honor. So he's provided me proof where he's gotten those text messages and, he has, because he has one from the 23rd, the 1st, the 8th, where he has gotten those text messages. And so when you get those text messages, do you respond yes or no, or do you just receive them and not respond? You don't respond.
Okay.
Okay.
See,
So he
okay.
understands. So I think he didn't realize that.
I know. Yes, sir. You're supposed to respond, even if it says you don't have to go, because we don't know if you're getting them. When you respond, we say, okay, you got the text. Now, the one that I'm concerned with is that you received a text on April the 30th. I'm sorry, you received a text, yes, on April the 30th for you to come down and do a urine test. That's why I say my system. And what I see is you did not show up on April the 30th for your test. Hang on, let your attorney speak.
So can we confirm the numbers? I'm looking at his text messages and he has one for 4/23 and then the next one was May the 1st.
All right, do you have that information, Ms. Garcia?
Yes, Your Honor.
What number do you have? Just give me the last three digits.
Yes, 1 second. 3812.
Is that it? Is that his number?
No. The number that he's been getting them at is 4695. He got one on the 23rd at 4695, and then he got one on May the 1st at 4695, and then May the 3rd on 4695.
Do you see that number on there?
No, Your Honor.
All right, so then it looks like we don't have your number, Mr. Whitney. Did when you first were here in March, did you have that same phone and that same phone number? And you provided that to Oh, really? Okay.
I was sure that they.
Oh, you were?
I asked him for his phone number and that's what I got. I even sent a message confirmation, because that's what I usually do when I instruct from here.
Yeah.
I sent a message, just to confirm that it's that phone number. And he didn't say that there were any issues that day regarding the phone number.
Okay.
Somebody sent him text messages, so I can provide it to pretrial.
No, I believe you. I believe you. I believe you. So, okay, let's do this. Is that the only phone you have? Okay. Can we make sure that we use that number that he has on his phone? We'll change it. Okay. And then just to make sure that we have that correct number, you're going to get calls. Now, I don't know how it is that you got calls if we don't have it in the system. I don't know.
We have this phone number.
Yeah.
And they just sending this text.
I don't know.
To that phone.
I don't know. Okay. It's okay.
He has no problem taking a drug test today. You want to take a drug test today? He said he has no problem taking.
I'm okay. No, let's, you don't have to do that. You're good. I trust you. No, no worries. But we do need to straighten it out. We need to make sure that this number that you have on is the number that we have on file. So that way you'll be getting text messages. So starting tomorrow, you'll be getting text messages at that phone. Now, when you get those messages, make sure you respond. You got to respond. The texts go out early in the morning, starting at 3:30 in the morning. Now you don't have to respond at 3:30 in the morning, but I do want you to make sure that you respond. And if you're requested to come and do a urine test, you have to come downtown. So I just want to let you know to check your messages early in the morning, because if you're requested to come, you got to come all the way downtown and you got to be here before 4 p.m. And if you don't make it, that's considered a missed test. Okay. All right. So do you need to see him, Ms. Garcia?
Yes.
All right. So let's do this. Right behind you is my pretrial officer. Go with her. We're going to make double sure we got all of your contact information. She's going to send you a text to make sure you get it. And then just make sure you respond, okay? You're good to go. You're fine. It's good to go. Yes, ma'am. You're welcome. And then you can just go over to your plea, and then whenever he's ready, we'll take care of it. Mr. Washington,
Hey.
what's up? How are you? Good morning.
John Hogan.
What's that name? Hogan?
Hogan. Oh, PVR.
Oh, is it? Let me see. Oh, yeah. Did you see what it was?
Yes, I saw.
Is it locked out?
Car accident. You reported that March 3rd as well as street trial.
Has he gotten it?
Quiet in the courtroom, please. There's too many loud conversations.
I just wanted the Tyrod kit. I don't want to snap.
Okay. How long will it take to be able to do that?
I'm not sure because I don't know his schedule, but I know for a fact that he can get it done by next weekend.
All right, so when did your car go down? Do you know?
Between the 22nd and the 25th, I don't know the exact date, but I did.
Oh, I see, okay. Of last month.
Are you on?
Okay. Okay, no worries. Yeah. The reason that you're here is because we received a message saying that your machine that you have in your vehicle went on lockout, which means that you haven't been taking it in to get it calibrated. And so whenever I receive something like this, I get a message. All right, so I just need for you to do this, Mr. Hogan. Get your car fixed as quickly as possible. Do you think that it can be done within the next week?
Yes, sir.
All right, so if it's repaired within the next week, you need to go over to your provider. Do you know what company you're, go to Smart Start, because they have to unlock it now. I'm not sure if you can drive it if it's on lockout. Yeah, so I'm not sure, yeah. He's not gonna be able to drive it, right? It's not driving, yeah. You have to tow it, yeah? Yeah, that's the problem, is that whenever your machine is locked out on your car, you can't start it. So it sounds like you have to tow it to a Smart Start.
I have I know bring it on a trailer or something, or.
Sure, however you can get there, however you can get, that's fine. They just need to make sure that they unlock it. Now, I'm not sure Do you know, Ms. Garcia, if it's agency pay, does he have to pay to get it?
You have to pay any fees regarding that.
Okay, yeah, that's what I thought.
Even if it's agency.
It is agency pay. All right, so Mr. Hogan, just unfortunately, because it's locked out, you're gonna have to pay to get it unlocked. The county is paying for your machine, but when it gets locked out, you have to pay a fee to Smart Start to get it unlocked. All right, just do your best, okay? Now, once you get it unlocked, make sure that you blow on that machine every day, okay? All right, you're fine. Just make sure you get it within the next week, and then we're gonna reset your case. It's still pretty new, right, Mr. Washington? Okay, we'll just reset it.
Okay.
Okay, so just have a seat, okay, Mr. Hogan? Thank you, you're welcome. Yes, ma'am. Good morning. Yes, ma'am.
Doing docket today.
Who do you have?
Voting, VOAT. Chief has just agreed to a mental health PTI.
Oh.
Her.
Okay.
And then, Heine Smith, AINE, same thing on that one, Judge.
Smith
Yep.
with an S, right?
With the S.
Okay, let me see. Smith. Oh, yeah, I got it right here. Same thing, PTI? Oh, yeah, so just get with Millie and we'll give you a date. You're welcome. Let me see, one more person you talk to. Faith Moore. It's been one of those days. Miss Allen.
I'm glad you're here now.
Man, you are Faith Moore. Miss Moore, you don't have a lawyer today, right? All right, Ms. Moore, I just wanted to inform you of what you are being charged with. You are being charged with the offense of lawfully carrying a weapon. That is a Class A misdemeanor, which means that you can get up to, 1 year in the county jail, up to $4,000 fine. Now, I see that this was an offense that was alleged to have occurred back on November the 14th of last year. You were arrested on this charge back in November. You were released on a bond. You were requested to come to court, but you missed your court date. So when you missed your court date back on November 22nd of last year, we issued a warrant for your arrest. You had a warrant for your arrest. I do see that you posted a bond in Brazoria County back in back in January. You were required to come to court on that bond, but you missed your court date. So you're supposed to be in court January the 9th. You missed your court date. You posted another bond out of Brazoria. Man, this is costing you money. And then I see that when you posted a bond, you were once again required to come to court, but you missed your court date again back on February the 7th. So now I see that you got arrested. This time you did go to jail. And I see that you went before a magistrate judge, a judge at the jail, and you were released on a personal bond. And now you're here. I do see that you were given conditions of bond when you were in custody, which I have to believe you have a copy of. I want to remind you that that is a court order. If you violate any of the conditions of that bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. So you are going to need an attorney to represent you on this case. You've got two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you one this morning? Court appointment, I'll appoint you an attorney this morning. I do see that you have another case in the 174th set from May the 29th, and you have a court appointed attorney in that one. Okay, I will appoint you an attorney this morning on your case, Ms. Moore. All right, Ms. Moore, do you have any questions on anything that I mentioned to you? All right, if you would just have a seat, I'll appoint you a lawyer, okay? Thank you. Millie, real quick, page 18, Faith Moore, court appoint. Yes, sir. No.
Approaching our trial case.
Oh, yes, this is on Nares. Okay, so what's happening?
Judge, I believe we came to agreement with the state. Just provided them information that the client has been denied since January. The client has been denied since January.
Really?
He's scheduled to successfully complete it on the 15th of this month.
Did he voluntarily go or? Oh, really? Okay.
He was already kicked out of PTI before. So he's doing that. By proof of that.
Now,
scheduled to finish on the 15th.
What happens once he finishes? What's the next step once he finishes the IOP?
Well, that's what we spoke with the state about. That we would dismiss. If that's what-
So is that what caused him to be removed? Was that he?
What caused him to be removed is, I guess in the program, I don't know the specific dates, but I believe he had a positive test or something. And there were two things that he didn't complete on time, or he didn't, they didn't have proof of completion, and he didn't basically. He paid those fees, he did all the other things as well, but I guess he just didn't do it time.
I see.
This is one where we've discussed this before, Judge, and that's why it's so old, is that he got kicked out of PTI. We got formal notice like a month before the dismissal date.
Right.
Despite the violations were way sooner, if they were gonna kick him out, they should have kicked him out, right? And he continued to do it, so we tried to see if there was a way to get him back. We got no month with that, and that's why we got all the.
Got it. So if he completes his IOP, then you anticipate that the state's going to dismiss the case.
We have a.
And is that something that Ms. Stiegler is mentioning, the chief?
Yes.
Okay. All right. Well, in that case then, and he is scheduled to complete when, May 15th? Oh, that's just next week.
So I wanted to get what you wanted to do about.
All right, let's do this. Well, no, if you believe that he completes it, I assume you'd want a dismissal rather than go to trial, right? All right, so let's do this. Let's take it off the trial docket and let's reset it past the 15th. And he's pretty sure, he's telling you for sure he's going to complete it on May 15th.
Yeah, we just provided the state a letter.
Okay.
This supervisor of that program.
Okay. And then when he does complete it, is he supposed to get some type of certification, some proof or whatever?
I'm sure he will. If not, we'll have them draft another letter.
Okay. So let's set it. Are you going to be around the following week, the week of the 19th? I was thinking of maybe setting him for May 22nd.
I love your button. So cute. Wow.
That's a week after the 15th.
I could be here May 22nd.
All right, so let's set him for May 22nd. We'll take it off the trial docket. Set it for May 22nd. If he's able to provide proof of that to the state, maybe they can dismiss it off docket before the 22nd. Okay. You got it. All right, thank you. Okay, yes, sir, come up. You got two cases, right? This is one of them, right?
It's the exact same plea with the exact same amount of time.
No worries. All right, so let's see here. Oh, it's Miranda is one of them, right? Miranda? Miranda and Palacio Sanchez? Yeah.
Si escucha su nombre, diga, sí, señor.
Okay, I'm just double checking to make sure I have the correct one.
Solo contestan español todo, caballero. ¿Cuál es tu apellido? ¿Cuál es tu apellido?
Carlos Miranda and Orlin Sanchez.
Okay, I got it right here. So. So these are two DWIs and two separate offense dates, right?
Yes, sir.
I got it. And
But
both.
were brought up and appointed on the same time. They just spent the same amount of time.
Yeah, I was gonna say, they both have 44 days credit, right?
And I'm kind of.
And they're both doing 132 days, both of them? Okay, got it. Okay, sir. Carlos Miranda. Is that, okay. And Orlin Palacio Sanchez. Okay. You are both charged with the offense of driving while intoxicated. These are Class B misdemeanors, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. You each signed some documents this morning. One of the documents that you each sign is entitled Misdemeanor Plea of Guilty. That document says that you all have certain constitutional rights. That document says that y'all have a right to have a jury trial. You all have a right to have confront any witnesses that may testify against you at that trial. and a right for your attorney to cross-examine those witnesses. However, when you sign that document, you give up all those rights. Do you understand, Mr. Miranda? Do you understand, Mr. Sanchez? All right. Now, both of you, I also have to advise you that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case. Your case ends today. And the other document that you sign says after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your case is in today. Do you understand, Mr. Miranda? Do you understand, Mr. Sanchez? Okay. Now, Mr. Miranda, did you sign all of these documents freely and voluntarily? Has anyone forced you to sign any of these documents? And has your attorney answered all your questions you have regarding your case?
Yes, sir. And I'm always.
Mr. Sanchez, did you sign all of these documents freely and voluntarily? Has anyone forced you to sign any of these documents? And has your attorney answered all of your questions that you have regarding your case? Yes, sir. All right. So, Mr. Miranda and Mr. Sanchez, Mr. Miranda, to the offense of driving while intoxicated, how do you plead, guilty or not guilty? Mr. Sanchez, on the offense of driving while intoxicated, how do you plead, guilty or not guilty? Okay. On the plea of guilty of each one of you, the court's going to find each one of you guilty of the offense of driving while intoxicated, assesses your punishment at 132 days in the county jail. You're each going to get 132 days in the county jail. However, you will be given credit for 44 days that you each have served. That is time served on your cases, no more jail time. Any court costs that each one of you might owe to the county, I'm going to run it concurrent with your time, which means that y'all will not have to pay any money to the county. However, as a result of these convictions, there will be a suspension of your driver's license for a period of 90 days. Okay, Mr. Miranda, do you have any questions on anything that I mentioned to you? Mr. Sanchez, do you have any questions on anything that I mentioned to you? And Mr. Savilla, do you have any questions? Mr. Miranda, Mr. Sanchez, good luck to both of you. Thank you. Thank you. Yes, ma'am. Come on up. Good morning. How are you?
I'm doing all right. How are you?
I'm good, thanks. What you got this morning?
I have somebody else out there.
All right, give me 1 second. What's the cause number?
2542-003.
2542003. Williams, yes, ma'am.
So I just filed yesterday a petition for an occupational driver's license.
Oh, I saw it,
I know that this court normally requires an interlock device.
Yes, well, actually, DPS requires an interlock, not me. It's a DPS requirement.
Okay, what I was going to ask about, Your Honor, is that,
Yeah, that's basically.
I have a personal car, but
This is what I
one
understand.
of the jobs, which is
So,
driver for an adult daycare, or they have vans that they have,
Yeah, yeah.
and it
You know, and it
changes.
seems like, I mean, I don't have
So she doesn't always drive the same thing.
It is, but I don't
Well,
know.
it may be a problem because it's not a requirement for the court because you're requesting a license. And this is a license that has to be approved by the Texas Department of Public Safety. Because it's not a privilege. A license is a right. I'm sorry. It's not a right, it's a privilege. So because it's a privilege and DPS is the only one that grants these licenses, they control the conditions. So the conditions on a occupational or restricted license for DPS requires an interlock. There's nothing that I can do about it. DPS will not grant her an occupational license unless it is that there is an interlock order or a vehicle has an interlock. So unfortunately, I'm sorry, there's nothing I can do about it.
Okay.
So I think there's a 1 year.
If there's a way that you think that she can have an interlock device installed in just one of the vehicles, that's great. How long is the license suspended for? Do you know?
It's supposed to be 180 days, and I think the suspension began almost 4 months ago.
So she's got 2 more months. Well, if she can hang 2 more months and just pay the reinstatement fees, she's got her license back and she's good to go and no interlock. I don't know. I'm sorry. I don't know what to tell you.
Sorry, at the very least, I can have her get it for her personal.
Yeah, exactly. For a personal car. Okay, no worries. So if she does get it, now that you're here,
Supposedly trespassing.
also my court report to Leal, because there's another form that you need to fill out, and then she can help you with that. And when is she on the docket?
She's set for May 14th. I was actually gonna ask if the court we want to roll her to the 15th.
That's fine. Yeah, just get with,
She was,
get with my coordinator.
Staying.
Let her know to roll up the
She was in this
15th and just get with my court reporter, Ms. Leal, and she'll give you all the forms that you need to fill out. And on the 15th, we'll be ready to go.
Thank you so much.
You're welcome. Yes, sir. Come on up. Okay, now I can take care of your case.
Thank you, Your Honor.
All right, what's the case number?
If we judge, it is 2486. Yeah.
That's tough.
Yeah, it is. That's what I thought too.
And Alita, it's a harassment. Let me look at it real quick.
This is involving past employment, no need for contact, anything like that, standard bond
Okay.
conditions. We have
It
those.
looks like a 2B warrant back on April the 10th. Do you have this case up, Miss Anthony?
Yes, Judge.
All right, let me see. I have to believe that no one's had any contact with the complaining witness yet, right?
That is correct, Judge.
Or we have PC in mind.
Well, the PC has already been found because it was a 2B warrant. Just kind of looking at it real quick.
That's right.
And do you see on this case, Miss Anthony, do you see any prior criminal history outside of Harris County? Let's call her up. I'm going to grant her a PR bond.
Thank you, Your Honor.
PR bond.
Yeah.
And Miss Garcia,
Yes, Your
I'm going
Honor.
to do a PR bond on this case. Can I give you the case number?
I have it, Your Honor.
Okay, because we want to also do bond conditions.
Yes, sir.
What's the amount of fair bond, Your Honor?
Let's see, $1,000. She don't have to pay for it though.
Of course.
All right, ma'am. You are Alita, is it Darian?
Darren.
Darren, okay,
Yes,
Miss
sir.
Darren. You're here with the attorney. You have a warrant for your arrest in reference to a charge of harassment. I see that this was an offense that was alleged to have occurred on April the 10th of this year. It looks like that there was a investigation that was being done by the Houston Police Department. The Houston Police Department were investigating a case, and they met with a person by the name of Amy Diehl, D-I-E-H-L. And she is the person that's accusing you of this harassment. So they met with her at the Houston Police substation, the West Side substation, on April 23rd. She told the officers that she's known you for approximately 2 years. Let's see, at a company called Adon Specialties, and that you were terminated from that employment October of 2024. She told the officers that she's seen you daily, and that she has communicated with you've communicated with her on numerous occasions. So she knows and recognizes you by name and sight.
She's seen me today.
Well, hang on. She stated to the officers,
Okay.
let's see, she told the officer that she believed that you were looking to her as a mentor. That during the employment, she noticed some actions that would cause her to worry. And then apparently she told the officers, that you kept asking her what's your favorite flower, then showing up the next day with a drawing of said flowers, and that she should get a tattoo. Eventually, She told the officers that she kept telling you multiple times to stop her unwanted behavior. And for a human resource representative to meet with you to provide counseling. Then you were terminated from the company October of 2024. And she told the officers, let's see. Afterwards, you continued text messaging her on her phone number. Looks like the officers saw those text messages. Let's see here. Text messages from October 27, 2024 to November 3rd, 2024, and she did not respond. Okay, eventually, she told the officers she began receiving text messages from you. So she told the officers that she has received over 100 unwanted text messages between April 10th of this year to April 29th of this year. So she decided that she wanted to press charges and went to go see the Houston Police Department, West Side Division. So afterwards, the officers looked at these texts. They contacted the Harris County District Attorney's Office, and the Harris County District Attorney's Office decided to file charges against you for harassment. And those charges were filed on May the 2nd of this year, and there was a warrant issued for your arrest. So now that you're here with your attorney, we need to go ahead and issue you a bond because you do not have a bond at the moment. So what I'm going to do, because I noticed that you've never been arrested before, no record, I'm going to go ahead and grant a personal bond, which means that you don't have to pay any money on this bond, and this will allow the warrant to be lifted. Now, what you're going to have to do this morning is, Ms. Darian, you're going to have to go over to the Harris County Sheriff's Department, approximately 2 blocks from here, to turn in this personal bond. If you do not do that, you will still have a warrant for your arrest. You're going to meet with my pretrial officer here in a minute. She's going to give instructions regarding that. Now, secondly, we're also going to issue conditions of bond. And the bond conditions that we're going to issue is in reference between you and Ms. Deal. The court's going to order that while you're in bond, you're not to have any contact with Amy Deal. Do not call her, text her, email her, Facebook, Messenger, Instagram, no contact whatsoever. Secondly, the court's going to order that you do not possess any firearms or any weapons. You got that right, Ms. Garcia? Yes, sir. Okay. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. We are going to reschedule your case to allow time for you to gather all the evidence that he needs. On your next court date, ma'am, you let your attorney take care of your case. He will let you know if and when it's necessary for you to return to court. All right. Ms. Darian, do you have any questions on anything that I mentioned to you?
No, sir.
Any questions? All right. A few one second. Millie, this is a PR bond that I'm setting up. I just need a date to put on the PR bond. It is, you got it? 256-2486. Okay, is that a good day, July 8th?
Once you know, you'll sign her, and then you'll go to the
Second. July 8th? Okay, got it.
What you do?
1 second.
Wow. Oh, fine.
Well, sounds nice.
Oh, she's not wearing clothes. Does she?
Oh, no, she wearing clothes. She better be.
I think she has a strap
Yeah, she does.
situation. Oh,
So.
Okay, who do we have here? I'm sorry.
Yeah, we have Mr. Derek Fields, Frields.
Exactly. I can do this. Called her son, who then calls me. So that would be I've never do. When somebody's messing with this.
All right, so you are Derek Friels. Is that you, sir?
Yes, sir.
All right, so you are charged with the offense of criminal trespass. You see here. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. You signed some documents this morning. One of the documents that you signed is entitled Misdemeanor Plea of Guilty. That document, sir, says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, sir, you give up all of those rights. Do you understand, sir? Now, I do have to advise you, Mr. Fields, that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents. One of them says that after today, you do not have a right to appeal your case instantly. And the other document that you signed says after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your case is final today. Do you understand, sir? Now, Mr. Friels, did you sign all of these documents freely and voluntarily? Has anyone forced you to sign any of these documents? And has your attorney answered all of your questions that you have regarding your case? Mr. Friels, to the offense of criminal trespass, how do you plead, guilty or not guilty? Are you pleading guilty because you are? Mr. Friels, on your plea of guilty, the court finds you guilty of the offense of criminal trespass, assesses your punishment at 132 days in the county jail. You'll be given credit for 44 days that you've already served. That's time served, no more jail time. Any court costs that you might owe to the county, I'm going to run it concurrent with your time, which means that you will not have to pay any money to the county. All right, sir, do you have any questions on anything that I mentioned to you? Ms. Kearney, any questions?
No questions from the defense, Your Honor.
Mr. Friels, good luck to you, sir. Thank you. All right, thank you.
Thank you, Your Honor.
You're welcome. Yes, ma'am, you're excused. Thank you. Okay.
Just how you doing today?
Good. What's happening? How are you? What you got this morning?
I have Johnson. Marissa Johnson.
Johnson, let's see.
I don't know.
On bond? On bond, right?
Yeah, I don't think it's here.
You're right, she's not. In fact, she's got a warrant for arrest upstairs. I don't know if you're aware of that or not.
Yeah, I know.
All right.
So I don't know.
Well, I'm going to just revoke her bond, and you're more than welcome if you want to, Mr. Bernstein, to file a motion to withdraw. And if you do, I will sign it.
Josh, throw down one in here.
I'm sure, ask Millie, I'm sure they do. I'm sure they do somewhere, because I've seen it. Okay, let's see.
So with that, let's just gotta get it, try to consult with an immigration.
I have one more. Miss Anthony.
Yes.
Oh my God, what a day, huh?
Yeah, I don't know who you spoke with, but if you want to know.
Court for that. How about that drink? That's the story of the drink. I haven't even touched it. I haven't even told you. This stuff, but it's got.
All right, I need to give you this case number, Miss Anthony. You ready?
Yeah, no, you look at me like.
62166.
William? Jones Williams?
Yeah, he's right in the box. Come on up, ma'am.
Yeah.
Jones. So this is for PC.
Yes, Judge.
And Ms. Garcia, can I give you this case number?
I got it.
Okay.
I've talked to Lily. I think I talked to Millie. And
And you are Lover Williams Jones. Ms. Jones, you don't have a lawyer today, right? All right, Ms. Jones, I see that you are being charged with the offense of evading arrest or detention. This was an offense that was alleged to have occurred back on April 28th of this year. I see that you were arrested on this charge. You went to jail. You were released on a bond and you were requested to come to court. However, you missed your court date on May the 5th. So when you missed your court date, there was a warrant issued for your arrest. I appreciate you coming to court this morning. Did somebody tell you to come to court this morning?
Yes, sir.
Okay, no worries. Because you did come to court voluntarily to take care of this, what I'm going to do is I'm going to go ahead and reinstate your original bond. And I'm going to have the warrant lifted. So you will no longer have a warrant for your arrest, okay? Now, we are going to have to deal with your case. So there hasn't been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the reasons why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We'll talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, whenever you're ready, may I proceed?
Yes, Judge. On 4/28, 2025, officers observed defendant in the middle of a roadway in Harris County, Texas, impeding traffic. Officer activated their marked patrol vehicle's emergency lights and stopped next to defendant. Officer was wearing full department issued uniform and attempted to make contact with the defendant. As officer approached, defendant began to run away in an eastbound direction for approximately 30 yards. Officer gave verbal commands for defendant to stop. Officer was able to catch up to defendant and detain her. Defendant later stated that she ran because she had a blunt and was afraid. Upon running driver's license of defendant, she was found to have multiple felony warrants out of Georgia, but Georgia will not.
All right, Ms. Jones, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of evading arrest or detention. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. So what we're going to do this morning, ma'am, is the court's going to order some conditions regarding your bond. So, Ms. Jones, the court's going to order that while you're on bond, you will be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited from consuming any controlled substance that you do not have a prescription for. No illegal drugs. These conditions of bond, ma'am, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, you are going to need an attorney to represent you on this case. Are you working right now, Ms. Jones? All right, there's two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you one this morning? I'll appoint you an attorney this morning, ma'am. All right, Ms. Jones, do you have any questions on anything I mentioned to you? All right behind you at the table. Now, preach officer, go with her, signs conditions, have a seat. We'll appoint you a lawyer instantly. Can you give this to Millie? Thanks. Millie, court appointment. Inslee's going to hand you the document.
Yeah.
You need a break, right?
She's in custody, that's why.
Okay. I guess I start signing all these orders.
I said, I was like, I'm looking for you, I said, well, I'll go ask.
Tomorrow. No, Monica's in a lot.
Okay, he just doesn't want to file it.
He's a two.
And I'll just move around.
And we're set the trial. It's a shit.
Oh, 16? I think it was 16. I think 25. Section. Should have emailed you. Oh, here it is. You just lost this. Why didn't the chief get rid of it?
They don't have a chief.
No, I mean, before she left, that's all.
Oh, I just got in there. When I got in there, the chief was gone.
No, I mean, it should have been resolved earlier.
So.
It was so
Brianna
good. It was really fun.
was waiting and then does her chief.
Yes, so now I'm just recovering from the trip.
I should have done that sooner.
No worries, I'll sign it.
Again, I feel like
Take
it
care.
was weekend. And I, this time,
He should have just missed it. It's his place.
yeah, so I feel like I've been like going and going, but once I sit down, I'm like, oh, God, I'm really tired. So,
That is .05.
No, I get it.
yeah, it was so
but,
much
like,
fun.
Brianna and.
Yeah, I
Still
took a
like
picture of it.
So you see if she answers.
This is one of my outfits. Yeah, it's pink.
This is in your.
Mm-hmm. So now it's the green. They like follow. It was really loud. We're covering our ears. And this is like the village. It's like literally it's so much dirt. And that's a church.
That's fun.
Village church. It was really hot. It's like the same as here, but like dry air. It's just like almost worse. Yeah, it makes it even more worse. Yeah, but yeah. That was like kind of like cotton. There's different fabrics. But usually for like the summer it's like cotton. So it's like breathable, but it's just like a lot of layers. So it like makes it hot.
Yeah.
Automatically.
I remember we were sleeping with the roots of the exams and
Yeah, so there was like basically like they do like an engagement the day before kind of thing. And then there's like 2 receptions after. And it's like it's like 5. No, it's not allowed in the village. In like the cities, you can't move, but not like in our area. But people like
She's in 7, I think.
people do that, like the men, the women. Yeah, it's like very stigmatized. Yeah. Yeah, but it was so good. Do you need help?
Yes.
Okay. Okay. Let's do the cotton.
Just give me a second. She should answer, but either way, we should be able to go over. But if it's next Wednesday, we have time. And she's in custody today.
That's why she's been in custody for like a month.
Yeah, and it's like you want to do.
I'm like, hey,
Okay, well, when are they done with that? 12:30?
Yeah.
Just give it, she should answer in like 10 minutes. I would. Perfect.
Thank you. What time are y'all done?
Probably.
Because I think that was one of his.
15 minutes.
Okay.
She should answer. It's just, there's certain things like DWIs and.
The reckless.
She'd be the chief of that.
Yes.
court.
She's no longer the chief.
No, I know, but she's more so.
Oh, yeah.
Yeah, and like Marshall.
Amended driver CC's.
The next change
Oh,
will be her over me.
And she's in 7?
You can go harass her in 7.
Okay, let me please.
Is that
Completed,
girl?
it looks, okay, it looks like he completed it.
Not 7, what's the lady's name?
I'm just trying to see if it was uploaded.
She's in that court.
Conditions were.
Andrews, Kelly Andrews.
Oh,
What court
this
is
is a
that?
guy. This is a guy who's in this court. The guy, just the judge.
Well, he's just sitting because Kelly Andrews is out.
Oh, really?
Yeah, she's out this week for some reason.
Yeah, I don't have the proof.
Okay, okay.
I think
Let me
it's
see if
7
I-
is Kelly Andrews' court, she's in there.
She's in Kelly Andrews' court.
Yes.
Thank you.
I was asking how many.
Oh my gosh, so many. But I went through all of them yesterday, luckily. Yeah, I don't have the certificate. I can email the defense attorney right now. They might have showed the prosecutor in the court, like in person.
So on.
Yeah, because he would, he never actually.
Is this whole?
Like, I received.
Oh, okay, okay.
I was gonna provide the certificate.
Okay.
That was an off-docket one, right?
Yes.
Okay.
Okay, it's not uploaded. They probably like showed a picture to the prosecutor who was here that we were both at that day. So they probably just showed a picture, but I'm emailing his attorney to get the proof.
Okay, perfect. Because if not, I just want to.
For the MHA.
No, well, because we didn't follow it, but the client is telling the client is telling the officer.
Oh.
They should provide it, but I'm like, that should have been already.
Right.
If you had completed it, but that's.
Yeah.
me.
No, I agree.
Because I have to picture it up there.
Okay, yes, I'm emailing. It's gonna be right now.
And then must be it. I just think,
Okay, perfect.
thank you so much.
Yes, thank
And then you
you.
can just, you
Okay, yes, I will.
Thank you.
Mhm.
God. Tell me if I'm crazy. So Nick is promoted chief in 16, blah, blah, blah. Because Marshall's out yesterday and today, what the fuck ever. So then he just sent that lady to come here because they have the trial date. I get it. But it's pretty high blood. I'm not really related to that core.
Yeah.
And Marshall's not here. I get it. I'm next door. My logic was, is she good at Brianna? Because she's more of the next chain of command rather than
Right.
four people on the same floor.
Yeah.
But now she can't be bothered with it. And it's just driving me crazy.
What she's like,
She's
no.
just like, I can't talk about this right now. I'll look in a second. You know, she's typing. Don't know why, but okay, we'll do. What? Tell me about it.
No, that seems reasonable.
Because he's not here, the chief.
Yeah.
And there's four of us on this floor, technically, because she could have gone to someone else and they could have been comfortable with it.
Right.
But it's not. You saw how I was with this guy who literally did DW guys in the sauce, and that's because it's my court, my problem.
Right.
I don't know, because I'm not being lazy here.
No, you're doing.
You can tell me if I'm being wrong, because I feel like I'm just confused. I don't know why.
Giving sex.
I don't either. She's like my best friend, but looking work that makes I'm very confused and frustrated because I helped her and she does not.
That's really weird.
But then no one helps. You'll learn that.
I'm scared.
Actually, she did my screenings because I despise screening.
Yeah.
And I did all of her rips.
Oh, that's good. That's smart.
And it was the perfect.
Yeah, trade on.
But like when I was in DVD covering for other people, no one ever helped me. So it's not even just her. I'm just like, anyways, I was just curious because you're more of the chief of this situation than I am.
Yeah. It seems more like she has ability to make.
I'm just not comfy. Smooth. And then I was like,
Yes. No, check her. And it's definitely. Okay. And if you don't know what it's like. I know. I'll be hard okay. Oh, did you know our guy? It's not okay. He's gotta be. What? Yes.
On this one, I'm gonna hold off. He's got court 5/12, so I'm gonna wait for the court date 5/12. So I'm not sure if you put it somewhere. All right, thanks.
For Hoskins? Hoskins?
Hello. Good morning. How are you?
I'm
well. Actually, it's not.
I'm gonna help. Yes. You can wait on the doctor. Wait on doctor.
Hi, Chief.
What if he shows up? What if he shows up?
He has an open felony warrant.
And we'll take him into custody. I'm not gonna sign a bond until the day of court. I'm not gonna sign a story until the day of court. If he doesn't show up, I will sign it.
He does not speak in I was appointed to represent him because I was the friend. And the foster home that was where that is my friend. Possible to be hungry so that even I was just working at the foster home. We phoned her, had her radio on loud and she had some on. Waking up. So we were trying to not be. Well, we were implication. And now he no longer lives in that foster home. What's wrong with him? It's over, no more issues. But. So that's. Would it be able to read?
Yes, ma'am. Yes, ma'am.
Regarding, Robert's case and BBR.
Yeah, the BBR, huh?
That still needs to be addressed, correct?
The what?
It still needs to be addressed.
I thought I did, because I remember the name, Roberts.
But she has to go to felony court, so I don't know if that's.
Oh, yeah, we did address it and we reset it. And she's gonna get her interlock today, she said. So we did address it.
Okay, thank you.
Oh, you're welcome. I know you've been busy, I know.
I'd rather not. Because of just an immigration that are happening.
Right.
Here now with those contracts. As potential, like, admitting liability in these immigration courts. So.
We just want to do it informal, like a very situation.
I believe this is all.
Mention or something, and then that warrant not having contact, or like.
All of this like status of Catholic Charities is representing on the immigration side, so. Yeah, I can.
Okay, cool, then that can be the warrant. Okay.
Yeah, very good. Let's just see what I can put together.
Thank you.
We'll go from there.
Okay, sounds good.
Thank you for your understanding.
I just don't understand how I'm wrong.
You're definitely not. It's so weird.
She could have asked 200 people on this court.
Right.
I'm not gonna dismiss it. I don't make that.
Right. That would be crazy.
I just don't wanna do that.
No.
I think it's okay. I don't know, whatever. We're bringing like 200 people last week. This one dying in the group chat, they're literally like, I'm not the chief, I'm prosecutors, it's just me, it's me, please help me. And it's like, oh, it's just, it's not that big of a deal.
Yeah.
It's just me of nobody.
Right, right.
Whatever.
Yeah.
That ain't how. You're lucky. Just fucking irritating. They in trial now? Didn't they end trial?
Yeah, they finished yesterday.
I don't get one.
And they're,
Kidding me?
yeah, like,
And why is she?
I would always be sitting in my.
The thing that's interesting is like, we all, not like she's a little stressed. Like, I went to her meet her family, they're like, oh my God, is it really that bad? And they're talking about like, we work in Afghanistan and I'm like, you know what I mean? Like,
Yeah,
oh, I'm like, I'm shocked at how she talks about this job. It's not that big.
Yeah.
I mean, whatever, though, teach them, just.
I feel like especially as like chief, it's pretty chill.
Right, people are young.
Yeah.
I don't know.
And the like 6 is super chill. I was in there, we didn't really do anything. We would talk most of the time.
Like this kind of, or
like this part, like all the time.
So it wasn't packed ever?
It wouldn't really be packed. The dock was a lot smaller per day.
Interesting.
Ms. Siegler, there is a case where there was a no probable cause finding by the magistrate on Nunez. I can give you the case number.
Is it Nicholas Nunez?
It's on the Nicholas, yes, it's on the docket today.
Yes, sir, let me take a look.
Okay.
Thank you.
Carmen, how are you?
I'm well, how are you?
I'm good. What's happening?
Will we see you at the?
I will be there today. We'll see you tonight. Take care.
It's like, I don't know, this, it's like they come in here and we're gonna be